Hello, good evening, friends. This is second session on the subject of cross-examination. In the first session, we had the introduction. Now, straight away, we go to the real battle. Ready for that? Well, an advocate has to prepare for the cross-examination. Unless you prepare for the cross-examination, you have to go through the entire case, the facts of the entire case, whether you have 1 week or 1 month or 1 year. You must go through the file completely. There is nothing like that. Without preparation, you cannot, my dear friends, you cannot cross examine a witness. So, how do you prepare for that? Preparation will again need technique. I was discussing in my last session that you must ask short questions, you must ask leading questions, and your questions should be simple. Now, again, what are the consequences of long questions if you ask complicated questions? First, the question may be disallowed by the judge. The witness may not be able to comprehend the question, or it may be difficult for you to get the right answer, because it's not that you ask a question for the sake of asking the question. You have to get the right answer, what you want from the witness to say. Now, let us assume you ask an open ended question: how such and such thing happened. Then you are giving an opportunity to the witness to explain the entire sequence of events, and some events may not be favorable to you or your client. So you have, and you will lose the control of the witness. The important thing, dear friends, is that you must keep the control of the witness. Let him answer the questions which you need. Let him not go away from you. Let him not be out of your control. If you need an answer in the yes, the witness should be asked a leading question. Yes, Mr. So and so, I hear that on so and so date you were present at such and such place. Either witness says yes or he says no. If he says yes and it favors you, good enough. If he says no and the witness is lying, he is not telling the truth, then you have a remedy for that. The remedy is suggest him that it is give him a suggestion that you were actually there on so and so place at such and such time, and you are lying to the court, and you are lying under oath. You know it. The witnesses are administered oath. They are under oath. So if they tell a lie, they can be penalized for that under the law. Now, keep your questions short, and very important, ask one question at a time. One question at a time. Let the witness not go out of control, because when you ask a complicated question, the witness may point to you, Mr. Counsel, I could not get you. What exactly you asked me? And then you, instead of the witness, you will have to explain your question. So that would be very difficult situation for an advocate. So dear friends, this is the piece of advice for you: short questions, simple questions, leading questions, one question at a time. Thank you. Next session we proceed with another very important aspect of the cross examination, what questions you should not ask, or the questions that should be avoided, in my next Key to Cross Examination session 3. Thank you.